Good afternoon. My name is Brad Allen, and I'd like to echo Les's comments and welcome everyone here today, and thank you for attending. I was at a seminar yesterday, and I was talking to two women, and one of them said, "Brad, you need a disclaimer. You need total deniability." And no surprise, she was a lawyer. The other woman said to me, "Brad, you have to be funny and you have to be interesting." Well, unfortunately, we're dealing with tax matters, so it's tough to be funny, but I promise you that I'll be as interesting as I can be. So I'm discussing the Canadian tax issues with Upstream loans from foreign affiliates. And before I start, I'd like to know by a show of hands how many people here have heard of or familiar with the new Upstream loan rules. So not too many hands. They've been around in draft form, and they were ratified about a year ago, so they've been percolating the tax community for the last few years. So I think what I can do today is give you an introduction to the rules and a few takeaways that will help you in the future. So I'm going to cover why the rules were enacted, and really why do we care as people who are involved in public companies and as tax practitioners, a brief overview of the new rules, steps in applying the loan rules, and finally, a few concluding remarks. So loaning money back to Canada has been a popular technique that's been done in the past, and under these new rules, that's still possible. However, there's certain circumstances that it will have to apply. And the new rules represent a change in government policy to curb abuses in using foreign affiliates. And this is consistent with the new foreign affiliate dumping rules that Les is going to talk about later on this afternoon. The two key points on this slide is the new rules are effective for loans after August 19th, 2011. And in typical government fashion, the rules are complicated, and in many cases, there's negative tax consequences to the unwary. For existing loans on August 19th, 2011, there are grandfathering rules where the loans don't have to be repaid until August 19th, 2016. So in this circumstance, there's time to deal with the loans. So what are the new rules? So typical tax legislation fashion, you've got an income inclusion, you've got some exceptions, you've got some deductions, and then you've got other specific provisions. And I'm going to focus on the income inclusion and deductions because those are really the key parts of these new rules. So the income inclusion, subsection 90, sub 6 of the Act, requires a Canadian resident taxpayer to include in income a specified amount, and for our purposes here, it's going to be the loan amount, in respect of an upstream loan made by a foreign affiliate of the taxpayer to a specified debtor if the loan remains outstanding for 2 years. And the specified debtor includes a taxpayer and any non-arm's length person other than a controlled foreign affiliate. And what's not on your slide, the loan amount is included in income in the year the loan was made. And I'll get to that in an example later. So on the deduction side, a deduction may be claimed if the upstream loan was a notional dividend to the Canadian taxpayer, and the notional dividend would be deductible to the Canadian taxpayer. And I'll work through an example of exempt surplus, but I'm sure you're all sitting there going, what the hell is a notional dividend? And of course, it's just, again, complicated rules. And so I'd like to go over an example. Example number one, you have Canco that owns 100% of lender foreign affiliate, and lender foreign affiliate loans Canco $1 million on August 31st, 2012, and the loan is still outstanding today. Lender foreign affiliate is a Peruvian company and has an operating mine. It earns active business income and loans the funds to Canco, to avoid the 4.1% Peruvian withholding tax on dividends. Under the new rules, this is an upstream loan subject to an income inclusion in 2012 because the loan was not repaid in 2 years. So next we look at, well, is there a notional dividend deduction available? And in this example, we have a lender for an affiliate that is earning exempt surplus, which is earnings from an active business in a tax treaty country. And if the foreign affiliate had instead paid a notional dividend to the CanCo, it would be entitled to a dividend deduction under current Canadian tax rules. So we have a regime where the foreign affiliate is earning active business income, pays tax in Peru, pays a dividend up to its Canadian parent company, and that is a deduction for Canadian tax purposes because we don't have double tax due to our tax treaties. So if this situation arises, then we get this notional dividend deduction, which would be available to offset the income inclusion. So I'd like to back up to the brief summary of the new rules and mention 2 points. The first one is the exceptions. So in any tax legislation, there's always exceptions. And in subsection 90 bracket 8, we have 3 main exceptions. The first one is going to be the most common, and that is for loans that are repaid in 2 years, but the repayment has to be not in a series of loans and repayments. The second exception is if the loan is from a company that is in a business of lending money. And the third exception if the loan is from a life insurance company. Also, I wanted to touch on when the loan is finally repaid, we get a deduction in the year that it's repaid. So if we move on to example number 2, in this example, we have a non-resident parent that owns 100% of CanCo, and CanCo in turn owns 100% of the lender for an affiliate. The lender for an affiliate loans $1 million to the non-resident parent, and that loan is on August 31st, 2012, and that loan again remains unpaid today. So again, we have another example where the upstream loan rules apply. And the reason here is because the parent is a specified debtor of CanCo. If we move back to specified debtor, it includes CanCo and any non-arm's length person, which includes the non-resident parent. This third example, we have a non-resident parent that owns 100% of CanCo, which in turn owns 100% of foreign affiliate number 1. CanCo also owns 40% of foreign affiliate number 2. The non-resident parent also owns 60% of foreign affiliate number 2. We have foreign affiliate number 1 lends $1 million to foreign affiliate number 2 on August 31st, 2012. And again, that loan is not repaid as of today. This is another example where we have the upstream loan rules applying. And on the surface, this one is peculiar because you have loans between foreign affiliates, and yet you have this income inclusion in the Canadian company. And unfortunately, it's because foreign affiliate number 2 is not considered a controlled foreign affiliate of CanCo, as it's not controlled by a Canadian resident. So the last 2 examples will give you a little bit of a flavor of the complexity of the rules and where you could be thinking that you have a loan that does not trigger these rules, but unfortunately you're caught. So how do we apply the rules? So first, you'd want to identify all loans to and indebtedness from a specified debtor. Secondly, you'd want to determine when the upstream loan rules apply. Third, you want to determine whether the upstream loan has to be repaid within 2 years. And then finally, determine if this notional dividend deduction can be claimed. So in conclusion, the rules are complicated and the devil's in the details. You need to review all foreign affiliate loans to identify any problem loans, determine the tax consequences of the problem loans, review the foreign affiliate group and look at restructuring options to minimize the effect of the loans, and then finally come talk to us if you have any problems.